Good morning, everyone, or afternoon, wherever you are today. Thank you for joining us to Minnesota Employment Law Update, what your business should know. My name is Tina Steering. I am a partner in Husch Blackwell's Labor and Employment Group, and I am based here in Minneapolis, Minnesota. I focus primarily on employment litigation. I represent both employers and management in emergency but the company cases, as well as litigation involving accusations of discrimination, retaliation, harassment, wage and hour violations, and wrongful terminations. In addition to being retained to do highly sensitive company issues for investigations. So before we begin today, and I know there was some scrolling through, but I want to cover a few housekeeping items. So at the bottom of your audience console, there are multiple application icons for your use during your program today. If you have any questions during the webcast, please submit them via the question box. We will do our best to answer those questions during the webcast today, but if we don't have enough time, we will certainly answer them via email later. A PDF of the presentation is also available in the program material file. The program has been approved for legal education hours. For live attendees, report your hours by clicking the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Toward the end of the program, be sure to complete our short survey. We use that feedback, your feedback, to plan future programs to make sure that we're meeting your business needs. So that is all for housekeeping, and we'll get started with the program. I'd like to introduce a few of the speakers, as well as someone who was involved in our programming and coming up with this concept. So joining me today speaking is Jonathan Duffy and AJ Weisler. Jonathan is also an attorney here in the Minneapolis office, and I'm proud to announce today, it's a little bit of change of his bio, but he has recently joined our Labor and Employment Group. He is also a member of our Mass Tort and Product Liability Group as well. He is based here in Minneapolis, as I mentioned, and his focus is both on products liability and employment law. For the products liability side of things, Jonathan defends clients against various chemical exposure allegations, and is particularly experienced in mold litigation after representing a military housing provider whose properties were allegedly contained substance of mold litigation. Jonathan's litigation employment background includes handling mediations and obtaining a dismissal after an employee was dismissed for an FMLA leave. He regularly counsels clients on federal and state issues. He works closely with me. He helps clients avoid potential litigation, and he also advises on employee handbooks. He also is really up to date on what's happening in Minnesota law in particular. Also speaking today is AJ. AJ is a partner in our food systems group focusing on labor and employment. He concentrates his practice on helping clients resolve many workplace issues that confront private and public employers, either by counseling clients through difficult personnel decisions or defending against administrative complaints and lawsuits. AJ has significant experience in defending against complex wage and hour, class and collective actions, as well as representing clients in discrimination cases before state and federal agencies and in state and federal court. AJ also has obtained favorable results before the National Labor Relations Board and the Occupational Safety and Health Administration. Before joining the firm, AJ was a clerk to the Honorable Dwayne Benton of the U.S. Court of Appeals 8th Circuit. And also participating in this program and helping us create this whole program is Jeff O'Brien. Jeff is a partner also in our food systems group. Jeff is a corporate and transactional attorney who thinks holistically about clients' businesses' needs, and he often has served clients for decades. Primarily a business attorney with a focus on corporate transactions, Jeff oversees mergers, acquisitions, joint ventures, and private security offerings. While he supports clients in a variety of industries, Jeff is also built a strong niche practice in the hospitality realm, often representing restaurants, bars, and breweries. After cannabis was legalized in Minnesota in 2023, Jeff began representing businesses in the burgeoning industry, hemp and cannabis industries, as well as becoming a leading attorney in the Minnesota cannabis world. Jeff works with clients who have branches and offices and restaurants across the country. He joined Husch Blackwell in 2024 to ensure a nationwide practice for his organizations that he represents. And Jeff is our newest leader of the firm's alcohol beverage practice group. So with that, we're going to begin this program. So we started this program, and I'll just tell you, frankly, we were focusing on this as being a great timely event because we were going to focus on what happened in the Minnesota legislative session in 2025. And I'll just tell you what happened. So from the legislative session was from January to May of 2025, and the session ended on May 19th. What was unique to this legislative session is that we had 67 Republican members of the legislature, and we had 67 members of the Democrat Party, or also known as, you'll hear, the DFL Party, the Democratic Farmer and Labor Party. The session ended, and there's hardly any resolutions to many things because of this tied party thing. And so we are likely going to go into a special session, and likely it will go into special session next week. The legislatures are still trying to work out a deal to talk about the budget, but all indications are that it's not happening. And so special session will happen. And so what we're going to talk about is our proposed amendments and current laws. And we're bringing up the proposed amendments as a result of what has happened, and what happened in 2023 was everything got bundled into the budget bill that eventually happened. So when you think about that, a lot of the proposed amendments might get added into this budget bill. And so we wanted to point these out to you because we're going to be monitoring it, and we will do another update on this after next week or the week after. Everything needs to be resolved by June 30. Otherwise, we will have to go into certain layoffs for government personnel. And so there's an incentive to get this all done by early June so that that does not happen. But the proposed amendments that remain pending that are relevant for employers are potential amendments to the Minnesota Earned Sick and Safe Time, the Minnesota Paid Family and Medical Leave, or also known as Minnesota's Paid Leave. There's certain non-discrimination laws, and then certain proposed amendments relating to job posting, employment agreements, and unions. And then there's a proposed amendment that did finally just get passed and bundled in, our meal and rest breaks. And I point that out again is that the proposed amendments, while remaining pending, can get bundled in to this bill, to the budget deal, just like in 2023 when cannabis became legal in Minnesota. And if anybody paid attention to what happened in 2023, the cannabis all of a sudden got legalized in Minnesota as a result of the budget bill, and it got buried in there. And it was just, quite frankly, nobody paid attention to that. So we just want to point that out to you. So what is happening with the current Earned Sick and Safe Time? So if people remember, there was an amendment to that back, and it became effective in 2023, and there was a slight amendment last year that went into effect. But under the Earned Sick and Safe Time, employers must provide each employee with 1 hour of paid sick and safe time for every 30 hours worked, up to at least 48 hours a year. And this applies to employees who work at least 80 hours a year in Minnesota, except for independent contractors. So if you're an employer who are sending employees up into Minnesota for even a few weeks or a month to do work, if they worked at least 80 hours in the state of Minnesota, they are eligible for earned sick and safe time. So you may be an employer based in another jurisdiction, but if your employees are coming into Minnesota and working at least 80 hours, this statute will apply to you. It also will apply to any employer with one or more employees, which is a pretty draconian obligation. The accrual of the earned and safe time currently begins the day that the employees start. The time can be used in 15 minutes increments, and you can front load up to 80 hours of ESST at the beginning of the year rather than doing an accrual. So that's the current law. So there were a couple proposed amendments, and they're still debating on it, but one of the proposed amendments would exempt employers with 15 or less employees. Another would allow for prorating the hours based on your full-time or part-time status. In other words, there would be less hours eligible for part-time employees versus full-time employees. That remains up for debate. The other would change that the notice for unforeseeable leave to be now as reasonably required by the employer. And then it would also allow for employers to ask for documentation if the ESST exceeds more than 2 days. It would remove certain PTO requirements, and it would allow employers to ask employees to find replacements unless the ESST leave is unforeseeable. So if you look at those proposed amendments, those are all very pro-employer proposed amendments, and they're all Republican-based proposed amendments. Those remain for debate. Nothing has currently passed, but while they're working through a budget deal, it's possible that some of these proposed amendments could go into play. The current paid leave is also a controversial law that has gone into effect, and it went into effect, but it begins January 1, 2026. So employers will need to start providing paid leave to employees beginning January 1, 2026. And that is one where it's been a source of great controversy. Now, the premium rate, and this is a payroll rate that has to be paid into by employers, is currently set at 0.88% for 2026. And you can pass on 50% of that to the employees starting in January of 1, 2026. The premium payroll rate is a little less for employers with less than 30 employees. And there's two types of paid leave. There's the family leave, and then there's this medical leave that would be paid for. And this would provide a wage replacement for employees that have to go out on the paid leave. And the wage replacement pay is this whole calculation, but in essence, it would be 90% of the weekly wages that are equal to or less than 50% of the state average weekly wages, and then a couple other employment factors in it. And there is a cap of about $1,000, $1,026 a week. So it's similar to like an unemployment benefits compensation that you'd be paying into, but now this is a paid leave for employees. The current paid leave also allows for leave to care for the child of a domestic partner. So it's not just a spouse, but a domestic partner. And the current paid leave law has changed the definition of what a typical work week is to the average number of hours worked per week by an employee within the last 2 quarters. For an employee to be eligible for paid leave under Minnesota law, this is a really important factor for Minnesota employers, or again, Minnesota employers are employers who are bringing in employees into the state of Minnesota, either for short-term projects or long-term projects, but they're really not based in Minnesota. Eligible employees must earn at least 5.3% of the state average annual wage in the state of Minnesota, or $3,500, which is equivalent to $3,500 in a 12-month period. So think about that. If you were sending people in to Minnesota on a short-term basis, you might be now under the paid leave law that's in effect. And so you really will want to look at your policies and procedures. Are you paying in? Because the paying in was required to kick off in October of 2024, and it's supposed to be taking place this entire year. And so employers need to be thinking about this if you're sending employees in. Now, you can opt out if you're providing an equivalent plan of paid leave in your policies. So you can opt out if it is equivalent to or exceeds what our state plan or state coverage requirements and benefits are. The proposed amendments, because so many employers are having issues in terms of have they even paid in. One of the things we've seen is a lot of employers we're working with didn't even know they were supposed to start paying into this fund. They didn't realize they were supposed to be having policies in place into their handbooks. They didn't realize how to implement this whole entire thing, even though the Department of Labor and Industry had been offering a number of webinars and programs on this paid leave. I don't think the state did a really good job in terms of educating employers on this. So one of the proposed amendments is that the paid leave be there be a delay in the implementation to January 1 of 2027 versus January 1 of 2026. That remains on the floor and is pending for consideration. It would also exempt certain employers, and they would be smaller employers, for implementation until January 1 of 2023. The proposed amendment would be smaller employers being defined as 50 employees or less. And then the proposed amendment, again, would exempt collective bargaining agreement employers. Currently, none of these proposed amendments have passed. Again, it's one where I think there may be some deals done. In talking to a couple of folks that I was talking to who are monitoring things on the Hill, they think that there might be some deals that could take place, in particular on this proposed, some of the proposed paid leave amendments. So that will be one to watch that we're going to keep an eye on. Then, in addition to what we're seeing in proposed amendments, is that there's also some proposed amendments to expanding the definition of non-discrimination under the Minnesota Human Rights Act. And that's our anti-discrimination statute that's in place. And the proposed amendments would expand non-discrimination to include provisions that you couldn't discriminate against someone who was using cannabis for medical reasons, for individuals in the healthcare industry who refuse to engage in medical intervention. And that's mainly for religious reasons. And then also our personally held beliefs, sincerely held beliefs. And then you can't discriminate against someone for their political affiliation or for political contributions. So those would expand the definitions for non-discrimination. What was also an interesting proposed amendment, and I don't see this getting passed, is it would allow employers to justify adverse impact of discriminatory practices if it related to the job or business purpose. So it would be akin to a bona fide reason that they would have to offer that we would see in certain Title VII discrimination defenses that we make. And then also for transportation companies, and when we say transportation network companies, we're thinking such as the drive share companies, where they would be required to make vehicles wheelchair accessible. So those are proposed amendments to discrimination. I don't see any of them getting passed except maybe the medical cannabis one, because that has been one that has been of great debate, and we could see that that would be the expansion on the proposed non-discrimination ones. Finally, there's some proposed amendments to job postings, employment agreements, and unions. And so one of the proposed amendments would require employers now to do a job posting on whether or not, so this would also not just be when we're posting for positions, but it's also posting on your bulletin boards where you disclose whether employee health plan options comply with the cost sharing limits under the state law. That seems to be one that, according to some of my friends on the Hill, seems like it's not a big controversy likely to get passed, but it's still, nothing has been passed because we can't get any agreements between our 67 to 67 group. The employment agreements, there is a proposed amendment that would prohibit stay or pay provisions as a condition of employment. And then there was a proposed amendment that, if you recall, non-competition agreements in Minnesota are no longer valid as of July 1, 2023. Now, that's only for non-compete agreements that are entered into after July 1, 2023. Those are not valid. The proposed amendment would allow for non-competition agreements for certain higher income employees who are earning more than $500,000. That doesn't seem like it's getting too much traction, but it's one where we see that could be revisited if we're trying to deal with a budget deal. This is one where we're keeping a pulse on it, where unions, there's a proposed amendment currently. If you are a striking labor employee, they are not entitled to unemployment compensation benefits. And this proposed amendment would allow strikers who stop due to a labor dispute to receive unemployment benefits. And so that could take a hit on employers for their unemployment compensation benefits and ratings. It also would allow striking workers to receive benefits if replacement workers are hired. So that might be one where there's maybe a hybrid agreement that could take place. There has been some progress, and there was one thing that was passed, and it was buried into one agreement that passed May 9th, and that is meal and rest breaks. Previously, employers were required to provide meal breaks for employees who were working more than 6 or 8 or more consecutive hours. And now it will likely be signed by Governor Walz, is that you must provide a meal break for an employee who works more than 6 hours or 6 or more consecutive hours. And you have to provide at least 30 minutes of a meal break. You also must provide an employee a rest break after working 4 consecutive hours of at least 15 minutes in length, or long enough time to utilize the nearest convenient bathroom, whichever is longer. And so and those are paid rest breaks. The meal breaks are unpaid still, but the rest breaks are paid. And the penalties now will include the regular rate of pay for the meal or rest break that was not provided, and for liquidated damages. So that has passed and will go into effect likely through the signature of Governor Walz, which we can see. Unemployment insurance also, there was some amendments that passed, and that went in effect May 9th. And there's now a penalty for employers who deliberately, now what's interesting is that it's a penalty only to employers who deliberately misreport facts regarding unemployment insurance. And it extends benefits to employees who were impacted by the Iron Range mine closures. So it's extending it to a longer period of time. And that has passed effective May 9. We expect that Governor Walz will sign that into law. So that is the quick update. We were hoping that we were going to have actual updates of what has passed and what we think Governor Walz would sign. So we are still going to monitor that, but we do expect that will, Governor Walz, I see one question, if signed by Governor Walz, when would that go into take effect? When would the meal and rest break take effect? It doesn't say. So that's one where we're monitoring it because they just reached that deal, but likely would go into effect the beginning of the year. But we will keep you posted on that. So with that, I'll turn it over to AJ.
All right. Thank you so much. And I am excited to be here. As was mentioned at the beginning, on the Husch Blackwell team, I am the interloper today for this Minnesota update, since I'm joining you all from beautiful Kansas City, Missouri. As was mentioned also, I clerked for the 8th Circuit, the Federal Court of Appeals, which has one of its main courthouses in St. Paul. So I have been to Minnesota many times. When I was clerking, it felt like my judge was assigned for argument in Minnesota every month, and for some reason, every month was winter. So I have been to St. Paul many times, but I have been outside in St. Paul only for the handful of seconds it took me to get from my car to the airport and back again. So as we look through this, I'm bringing the perspective of certainly experience with Minnesota law, but also a national practice in wage and hour law that certainly impacts the way independent contractors are viewed within Minnesota and without. And also, I think I'll add to what I think many of your ears perked up on the meal and rest period law that was passed, earlier this month. A lot of my practice is in states like California and others that have adopted meal and rest period laws. It becomes a very popular enforcement mechanism for plaintiffs' attorneys to bring lawsuits against employers, mostly for innocent or technical mistakes. And a lot of times what happens is they use that as sort of an entree, a gateway claim to then get additional detailed records on your time and your pay and kick around and see if they can find other things. So certainly that is a law to pay attention to, that in some ways, as these laws get more detailed, as employers, we feel, oh, well, now we know exactly what kind of rest breaks and exactly what kind of meal breaks we have to provide. But it also becomes very difficult to ensure that you're doing that correctly for every employee every day. So as somebody, and many of you, I'm sure on the call, have had sort of the war stories and experience of dealing with these claims in California, in Wisconsin, and some other jurisdictions where they're popular. So you're going to know not to take that lightly. And it's neat to hear the update coming from Minnesota. It's interesting. I know from my high school quiz bowl career that the official nickname for Minnesota is the North Star State, but I also always referred to it as the land of 10,000 lakes. And it feels like you all are heading towards the land of 10,000 employment laws as well, which will certainly keep us and you all very busy. But before we dive back into the specifics of Minnesota's rules, we're going to talk briefly about sort of the yo-yo experience that Minnesota employers and employers everywhere are dealing with when it comes to federal independent contractor status. So under the federal law, there are a number of different employment laws that care about whether or not you have an employee or an independent contractor. We're talking about tax laws, obviously, but we're also talking about discrimination. And we're also talking about overtime. So the one we're going to talk about specifically today is the rule that determines whether somebody who's providing services for you is an independent contractor who does not have minimum wage and overtime protections, or an employee who does. In that law, the Federal Labor Standards Act had a rule that was first issued in 2021. And that was this was under the Trump administration, and that was intended to define independent contractors in a way that harmonized these old laws, the way courts had interpreted it, in order to determine it. And they did it with, of course, a multi-factor test, because that's how we do a lot of these things. And ultimately, it was meant to suss out, to figure out the economic realities of the employment relationship or the independent contractor relationship. Is this somebody who was independent financially from your business, or is this somebody who is a cog in yours and not their own? So it issued a ruling or test that's 5 factors, but 2 are the core factors that should be emphasized. And if you look at those, a lot of them, especially if you've dealt with independent contractors anywhere, these are familiar factors. So we're talking about how much control are you exerting over their work. We're talking about, can the person doing the work win or lose? Can they personally lose or win based on the financial realities of the deal? And then there are some other factors less important. For those of you who have a business model that includes many hundreds, thousands of independent contractors, right? The way that these tests are laid out are significant. Being able to draw a line between, what is and what is not an appropriately classified independent contractor, can have significant impacts to your bottom line. But even companies that don't have a major component are often dealing with independent contractors, sometimes at the employee's suggestion, right? Where somebody says, hey, I'm ready to semi-retire. Maybe I can go into a consulting role and I can still do exactly what I'm doing for you, but I'll be a consultant and you'll pay my LLC. It could be through an acquisition that you bring in a new business segment, and for a period of time you transition by having previously employees of the old company now are going to work for you as independent contractors. It could be that you're just hiring contractors to do work around your offices or to provide services that you view as truly outsourced. And so you look through these rules, and you're going to find, as we yo-yo back and forth on what these standards are, that there's not a huge difference in the outcome, right? Some that are obviously contractors, the people you hire to come paint your kitchen, you're going to be are going to be safe no matter what test is applied. And then there are others, the ones that are in the gray area that we're going to focus on a lot, versus those who are, obviously and more plainly your employees. And so as we look at this rule, it was fairly immediately rescinded by the Biden administration. So in 2024, the Biden administration got rid of the rule, issued their own, and they said that, look, these economic reality tests that the court and DOL had used for years were much more stringent, strict. They had fewer independent contractors than the test that the Trump administration had put out. And so they rescinded it and they put out their own rule. So the 2024 rule, which was a totality of the circumstances test, by that we mean we look at all of these factors. It's not a checklist. You don't have to sort of say each of these, is green, therefore they're independent contractor, or each is red and they're not. Instead, you look at all of them to try to figure out what kind of relationship do they have. And a lot of these tests, as we compare them side by side, are going to look awfully familiar. So for example, both tests focus on the amount of control. They just put them in a different spot in the order. This, by the way, feels like an elementary school assignment that I've helped my kids with, where they have to sort of match definitions or find similarities. So if you're playing along at home, you can move ahead. But yeah, 1 and 4, we have control. 2 and 1, we've got profit or loss. So both of the core, 2021 factors are still there in the 2024 rule. We have skill is certainly focused on, the 2024 rule brings in initiative. So wanted to make it clear that we're not just looking at employees who are highly skilled, but also employees who demonstrate initiative, which is obviously something we always want to focus on with our elementary school students as well. We have permanence. So the degree of permanence, meaning, is this an ongoing long-term relationship, which is more likely to be an employee relationship, or is this one that has a beginning and end date that tracks more directly with an independent contractor? And then there are some factors that are a little bit different between the tests. So for example, the 2021 rule focused on whether they were part of an integrated unit. So like if you have a production line and 7 of the 8 individuals working there are employees, and you have 1 who's an independent contractor, that will raise red flags under the 2021 rule. The 2024 rule focused on investments. So it kind of fits under this profit or loss concept, but who's putting the money into this business and this work, who's buying the tools, who is, spending money to support the work that's being done. And then number 5 is this concept of whether they are integral to the business. So can you, as the employer or as the company who has an independent contractor, function without them? Or are they doing the work that you yourselves are then selling to the public? So there's not a huge difference. And instead, as you can kind of sense from the way they're phrased and the degrees, we have a 2024 rule that's intended to identify more independent contractors, and the 2021 rule that's intended to find fewer. But again, we're just talking about those gray areas. So what's going to happen to the 2024 rule? Because we have, as of January, a new administration. So not surprisingly, it's not going to live. It's not going to survive. It is still technically on the books, meaning it has not been formally rescinded through the administrative process for notice and making a new rule, but it's on its way out. Almost immediately, the Trump administration took cases that they were pursuing, meaning the Department of Labor, and they looked to get those cases stayed so that they can change the rule and ultimately dismiss them, or at least pursue them under the new rule. They identified or indicated that they do plan a rulemaking that will happen at some point over the next several years, that they're not going to be enforcing that old rule in any new cases, and they've even asked to formally abate those matters. So what rule exists now? So if we look at this, we've got a May bulletin, so as of earlier this month, I should say, that immediately said we're going back to July of 2008. I wish that my waistline could also go back to the way it was in July of 2008 so easily, but all we needed was a bulletin here under the Trump administration. And so we've now moved to a 7-factor test. So we've gone from the 5 rules that we had and on 6, and now we've got 7. And the 7 factors here are going to look awfully familiar. So, for example, control is still crucial. Profit or loss still hangs out. Initiative, judgment, foresight. That sounds an awful lot like that skill and initiative that we saw in the previous rule. Permanency is still there, and even some of the previous outlier terms are still there. Again, is it integral? Who's making the investment? There is a 7th factor that was not explicitly included in the previous tests, whether this is an independent business organization or operation. It kind of tends to capture a lot of those previous 6, but basically looking at is this person, this employee, are they operating in a way that is truly independent of the employer? If so, there's a better chance that they are properly classified as an independent contractor. So why do we care about this in Minnesota, maybe even more than other jurisdictions? So that federal rule, which again, specifically the federal overtime rule, is not and does not directly govern how we determine independent contractors in Minnesota. But in Minnesota, we have, and we care deeply because the tests are similar. Probably the outcomes are awfully similar to a lot of these tests we've been talking about. We'll look at those rules in a moment. But in Minnesota, you all, I should say we, for those of us who are advising Minnesota employers, we have heightened penalties. They're significant. They're effective last year. And one violation in the great state of Minnesota where you have misclassified somebody can be $10,000. So because of those zeros, the math is easy. You have 10 independent contractors who are misclassified and you're into the 6 figures, and 100 of them gets you to $1 million pretty quickly. So if you are an organization that sends out a lot of 1099s to your workers, especially if you're doing it to the same people every year, it is certainly worth paying close attention because the penalties have gone up, and that is a penalty that is on top of not, to replace all of the other ways in which you may have to pay additional funds to somebody who was misclassified. So we're talking about things like the minimum wage and overtime that they were not getting while they worked for you, shift differentials, vacation pay. There are all sorts of penalties there, including, truing up benefits, including them in your benefits plans if they should have been. And that can obviously cause a substantial amount of expense and difficulty to sort of unwind all of those issues. And you're not just sitting around waiting for the government to show up, because there is a private right of action where individuals in Minnesota can sue their putative employers directly, claiming that they were misclassified, and seek most of those same compensatory damages. Minnesota's also.
Chime in on that.
Oh, please.
Just to chime in on that, I just presented on this with a plaintiff's lawyer last week. And he said that this is like a ripe new area for the plaintiff's bar. So.
And anytime it's a ripe new area for the plaintiff's bar, it means it will keep us and you all very busy. And it means also that in addition to, it's a good segue to this. So a lot of you all who have independent contractors that you work with likely have, engaged in sort of, arm's length negotiation with those individuals. A lot of times they requested it, they agreed to it, they signed a document that said, yes, I'm an independent contractor. And so you end up with, a situation where they are rarely the motivator for an action claiming that they were misclassified. As long as they're paying their taxes and as long as everybody's happy, as long as they are gruntled as a worker, then we tend not to hear about this. Where these things pop up, especially in states with increased legislation and increased regulation like we see in Minnesota, is where somebody leaves your employ or engagement and they are not happy. And they are disgruntled, and they go to a plaintiff's attorney a lot of times to complain about something like, I didn't get paid, or they docked me pay because I didn't turn in a computer, or they, I believe this was discrimination. And that plaintiff's attorney listens, nods along, and then says, "That's great, but how were you paid? How did they how did they do overtime? How did they do meals and rest breaks? Tell me about your engagement." And when you say, or that person says, "I'm an independent contractor," it immediately raises that flag and gives an opportunity for a plaintiff's attorney to come seek out an action. Otherwise, you tend not to hear about these issues unless you happen to be subject to some sort of government enforcement. And that's usually nationally and in most states going to arise from an employee complaint as well. So somebody who says, I don't believe I was classified correctly, and then you get investigated. Minnesota is joining a larger coalition of states around the country that are focused on this issue and are going to be, taking the initiative to pursue and investigate independent contractor status without an employee complaint, without a plaintiff's attorney bringing it to their attention. There was an audit that said that they believe nearly a quarter of Minnesota employers are misclassifying at least one employee as an independent contractor. The independent contractors have grown to about 10% of the Minnesota workforce, which means that we're focusing on things like gig work, the ride share drivers, the food delivery individuals who are classified that way. And they're trying to put a focus on ensuring that those classifications track with the rules. And those rules in Minnesota, this is for everybody but construction industry. It's a 5-factor test. You probably were ready for at least more than 4 factors. And you're going to see a lot of the same terms, the same issues that we look for nationally. We're looking at the right to control, that first one, the mode of payment. So is this somebody who's getting paid a lump sum for an entire engagement? Are they getting paid by the hour? The furnishing of tools and materials. This goes to that profit or loss concept. Am I having to bring my own stuff, and therefore, if it doesn't go well, I'm losing money, or am I just showing up to a job and being given what to use and what to use it for? Again, control over the premises where it's being done. Is this, my kitchen? Is it your kitchen? Is it the workplace where I'm sitting inside of your location and I'm subject to your rules while I'm there? And then the right to discharge. So the relationship between, am I subject to just a contract that I can terminate, or is it a situation where I can terminate somebody at any time? And there's a new test for the construction industry. So effective March 1st, so just a couple months ago, a 14-factor test went into effect. So the land of 14 factors now in Minnesota, specifically for the commercial construction industry and residential construction industry. And it is a conjunctive, have to hit every factor test. So that means that we're talking, that in order for somebody who's working in the construction industry to be properly classified as an independent contractor, not an employee, they have to hit all 14 factors. So not a totality of the circumstances. We look at it and feel our way through to a decision. This is a checklist that you have to hit all 14. And that checklist is extremely detailed. It has to do a lot with licensing and carrying insurance and ensuring that that company is truly operating as an independent contracting business as opposed to somebody who you have hired. So if you are an employer in the construction industry, I'm sure you are well aware of this law in Minnesota. If you are not, if you are outside of this industry, it does apply to employers who are bringing on contractors to do a remodel, to do new construction for their own businesses, and it's something you're going to want to pay attention to. And it's gotten certainly plenty of attention, including a lawsuit that was filed in February, where a group of builders challenged this law, saying it was too vague, meaning somebody who read this law wouldn't understand it or be able to apply it. And they sought an injunction, which would have sort of immediately taken the law out of effect before it became law in March. That was denied, and that denial has been appealed to the Eighth Circuit, where some of my old colleagues are going to be reviewing the briefs and hearing argument for it soon. We anticipate, if this sort of follows the typical schedule, that argument would happen sometime in the fall, either September or October, with the decision following a few months after. So there will be a decision there, but in the meantime, that law is in effect. And again, with the types of penalties we're dealing with in Minnesota, it is certainly worth paying attention to. We'll move away from independent contractors to touch a bit on tip pooling in Minnesota. Minnesota is unique among states, not entirely unique, but it's certainly, I guess, rare is the better way to say it, because it's one of only 7 states that does not allow a tip credit. So a lot of states allow you to use a tip credit against the minimum wage and overtime requirements. Minnesota does not. So when we're talking about tip issues or payment issues in the state of Minnesota, we're typically talking about tip pooling. And there were a couple of new rules, one from last year, one from this year that affect that. The one from last year was a requirement that tips that were paid electronically get paid immediately to the employee. So as soon as they have to be paid out in the next pay period. They can't be sort of held for any period of time and then paid out in the future. So there was a practice among a lot of employers, typically just administratively, where there would be some lag between when like a credit card was paid with a tip and then the employee received that tip. Since last year, you can't do that. Similarly, since the beginning of this year, there's now a ban that says you cannot have any kind of service fee that's not directly a gratuity that gets added to a bill in the hospitality space. So we can no longer have anything that's called a service fee or any kind of thing that doesn't go directly and entirely to the server. So mandatory gratuity is still allowed, any other fees are not. And that means we are dealing with, again, this concept of tips that go directly to the server, and they have to go to them directly in the next pay period. There is currently, both at the state and federal level, a lot of attention on tip credits and tip pooling. That means that if you are a company that has tipped employees, these new regulations are similar to the independent contractor space. They're subject to scrutiny, additional scrutiny. So it does create a real incentive to not wait for someone to knock on your door or for a lawsuit to show up before checking what kind of policies you have in place, how you tip pool or whether you tip pool, and whether that complies with the rules in Minnesota, which are stringent. Not only is there no tip credit, but the tip pooling is also more restrictive in Minnesota than it is federally. So certainly worth paying attention to if that's something your employer deals with. And with that, we will transition away from independent contractors and tip pooling in the wage and hour space that I'm in, and instead we will send it over to our last presenter today, Jonathan, to talk about some notable cases.
Thank you, AJ. So today we just want to go over two notable cases in Minnesota. One dealing with the first criminal conviction regarding wage theft, and another one regarding business discrimination against a transgender athlete here in Minnesota. So for the first case, the state of Minnesota versus Frederick Newell. In this case, a contractor submitted an application to be the contractor for a affordable housing project in Hennepin County, the Redwell. And as part of that, the general contractor had to subcontract out a handful of pieces of work, including painting and a final cleaning. And in this case, Frederick Newell and his company, Integrated Painting Solutions, was the company that won those two bids. Now, since this project involved public funds, that meant prevailing wages were in play here. In this case, it would be approximately $56 for painters and another $56 for general laborers. And now that includes the prevailing wage and fringes as well. Mr. Newell, throughout this contract, was paying his employees between $15 and $25 per hour, and then submitting falsified payroll records to cover up for that discrepancy. So 5 employees between June 8th and December 4th of 2020 were underpaid approximately $47,000. And again, this was covered up by Mr. Newell submitting certified payrolls to the contractor that weren't necessarily true. So eventually, the employees made a complaint to the Minneapolis Civil Rights Division, and Mr. Newell agreed to pay back the back pay prevailing wages in June of 2021 of approximately $43,000. And the first payment was to be made by September 13th, 2021. Now, Mr. Newell did not make any payments, and in fact, the general contractor ended up paying employees not only the wages they were owed, but also the original contract they had with the defendant. In Minnesota, the wage theft law is a felony to steal more than $1,000, which is similar to other thresholds in terms of other thefts here in Minnesota. And eventually, Mr. Newell was found guilty of intentionally shorting 5 employees more than $37,000. And this sentencing will take place in June 6th. And while the judge noted that probation is likely expected, there are a handful of factors here that may point to a longer sentence, including the major economic offense of how much money was withheld from these employees. Multiple victims here, there were 5 employees that were not paid, and a high degree of sophistication or planning over a lengthy period of time. So, as I mentioned before, this went on for about 6 months, and the court found that was a high degree or a long period of time that this was planned. this topic, these construction workers, is really a big theme for the Attorney General here in Minnesota, to the point where during a press release regarding this case, they had mentioned that while robbery causes losses of up to 500 million, wage theft causes losses to workers of up to 15 billion. So there's a clear effort, not only in the construction industry, but in worker protections in general, to make sure that contractors and subcontractors are accurately paying their employees. And with this, there's another case similar to this that was just brought recently regarding a dairy farmer who was charged with wage theft and racketeering based on allegations that he intentionally underpaid migrant workers. Now, the facts of this case are arguably significantly worse because they were being paid $12 per hour, working 84 hours a week, but then they were charged $75 an hour to sleep in a small bed, cockroaches and bed bugs and everything. So this case is significantly worse. The hearing is set for June, and we will continue to monitor this case. Now, on the flip side, we have J.C. Cooper versus USA Powerlifting. And that is a case that touches on business discrimination on the basis of sex and sexual orientation. So to start, a transgender athlete, J.C. Cooper, was denied entry into the women's division of a powerlifting competition after she submitted a therapeutic exemption from the USA Powerlifting's drug-free policy. Now, this medication was taken to treat their gender dysphoria. The district court initially enjoined the defendants from holding competitions in Minnesota until their policy complied with the Minnesota Human Rights Act. USA Powerlifting appealed, and on appeal, they argued that the decision to not allow J.C. Cooper to participate in the women's division was because they had gone through puberty as a male and therefore would have an unfair strength advantage over those who went through puberty as a female. Now, the Court of Appeals agreed with this argument and reversed the district court's grant for partial summary judgment and the order for injunctive relief. And the Court of Appeals reasoned that its decision is related to and intertwined with the transgender status, but that does not make it a discriminatory reason per se. And that the distinction between discriminatory decision-making and legitimate business decisions that may be interconnected with a person's status as a protected class member, there is somewhat of an overlap there. And at this point, the case was appealed to the Minnesota Supreme Court and was heard on December 8th. So at this point, we're just waiting for a decision, and we'll certainly keep that up as well. And this also affects employers. As Tina mentioned earlier, there's potential proposed amendments to the non-discrimination section, and one of those would address the adverse effects of a discriminatory action if it's related to the job or business purpose. Now here, USA Powerlifting is saying that this is a legitimate business purpose because J.C. Cooper would be unfairly, the way she was when she transitioned after puberty has a significant impact on, I guess you could say, the business of USA Powerlifting. And with that, I will pass it back to AJ to wrap up.
Thank you. And we actually, we have the luxury of a few minutes here, primarily because as a lower Midwesterner, I speak very fast. And so I was able to save us a couple of minutes. And we have a couple of questions that I think were raised in the chat and likely have some impact for more than just the people who raised them. So I'll address one and then I'll send it to Tina, and she's got a couple as well. The one question came up, and it was sort of presumably during the independent contractor part of this, but it was certainly relevant to others, and that is, how do all of these independent contractor rules, employee versus not employee issues, how do they apply to somebody who is an intern, right? A temporary individual who was brought on, and it's sort of the quid pro quo of the relationship is that they're gaining experience in your industry. They are sort of learning and growing in their abilities and exposure, knowledge, et cetera. They're doing specific projects for you as an intern. And the short answer is that the test is the same, right? So they are not, calling them a student worker, calling them an intern doesn't change the test for whether or not they're an employee or an independent contractor. This is assuming that you're, not a government entity. So if you're a private employer, then you have to go through those same factors and all of those multiple factors. And certainly, the nature of the work may allow you to lump them safely into the independent contractor space. But if they're there to learn from you, and if they're there to develop, it's hard to argue that they are bringing their own sort of initiative and skill to the relationship. And if they're there doing similar work to what your other employees are doing, that is a particularly big and loud red flag. So it's hard to, and often very, very commonly misclassified, to call these interns anything other than employees. They are, at that point, temporary employees. They understand that their time with you is not going to be open-ended, but it does not put them, that factor alone does not put them into the independent contractor space. And I know that there's that same issue comes up under some of the other amendments that were proposed.
Right. And so to piggyback onto that, AJ, if that intern fails to meet the independent contractor test and is not associated to a true internship where it's associated to a degree or a trade, then likely the Minnesota ESST and the Minnesota paid leave laws will apply. So you'll want to be mindful of that. So it needs to be a true internship. Otherwise, the laws that we talked about at the beginning, the earned sick and safe time and the paid leave would apply. I see also we have a question for the break changes. If our employees have a paid lunch, does it have to be 30 minutes? The way that the way it's written is that yes, it will need to be still, even if it's paid, you still have to provide 30 minutes under what's been passed. Now, again, it hasn't been signed into law by Governor Walz, and I know that question came up, is whether or not, when will that go into effect? And so even if you're giving paid meal breaks, you still need to give them that full 30 minutes of that meal break. And I know one of the other questions that came up was for I think it was going with the paid leave, or going with the paid leave, is that if there's companies with less than 30 employees, the current law is that there's a lower rate. And so would that include out-of-state employers who have a low number of employees residing in the state, or is it based upon the size of employees in the whole company? And that is the paid leave law, and the reduction of the payroll premium rate that would need to be paid into is based on the number of employees actually physically working in the state of Minnesota. So it's not based on where you're headquartered or located, and it's not based on where your employees are residing. It's where they're working. And so if you do have remote workers who reside in Minnesota, though, then that paid leave law will go into effect and will apply to a remote worker living in Minnesota and working in Minnesota. So you'll need to be mindful of that. AJ calls Minnesota the land of 10,000 lakes. I call it the very northern district of the state of California, with how the laws have been evolving for employers. It's a difficult area to navigate.
And we'll leave on that extremely positive thought as we end our program today. So a couple of quick things. First of all, thank you so much for joining us. We really appreciate anyone sharing their time with us as we get to talk about areas and the things we're passionate about and what we do on a daily basis. And certainly hopeful that we were able to provide some information that was helpful to you and to your organization. A couple of reminders. One, it has been approved for the legal education hours. Make sure you use that CEU button. It's at the bottom of the screen to report it so that you can get your certificate and get credit for it. You will receive that certificate along with a link to the recording of this presentation, and that you will receive at some point tomorrow. You can share that link, as I'm sure there are probably dozens of people you thought would really enjoy getting to spend an hour with us, and we're just unfortunately too busy today. Be sure to complete your short survey. There's another link for that. We really appreciate the feedback that you give us there. It helps us make sure that future content that we provide is as helpful for you and your organization as possible. So with that, this concludes our webinar. Thank you.